Well, good morning, everybody. Back to work, I suppose. Back to the Steve Drizin and Leo Richard Leo article. We had our fun over the weekend. Now it's back to the serious stuff of going through the next part of false confessions in the post-DNA world. Just to remind you where we were up to, we've just read through the bit about Ryan Harris, who was murdered, a little girl. The police, in their infinite wisdom, arrested two little boys, both under the age of 10. I think they were 9 and 8. Absolutely ridiculous. Sent them off to be tested, observed for a couple of days. The experts say these kids are completely harmless, but still, when handed back to the police, they were allowed out with electronic tags. The kids were so small, they didn't have electronic tags small enough. They had to be specially made for these two little kids. You know, it makes you wonder, are the people in control there? Maybe they just don't have kids, you know? Maybe to them they're a bit like Professor Umbridge from, Harry Potter, who just hates children. Anyway, moving on. This is B, vulnerable populations, juveniles. In fact, we're around about page 74, if memory serves me right. So anyway, there are 40 false confessions in this article's database from suspects who were under the age of 18 at the time they confessed. Precisely why these young people falsely confessed is not always clear. In most of the false confessions, we do not have audio tapes or videotapes of the interrogations, making it difficult to ascertain whether a particular police tactic triggered the false confession. I'm just going to interject there. I can't help thinking that with these kids, they have no sense of reality as to what they're saying, the implications of what they're saying for them, and they don't realise that this is for the rest of their life. I despair of people that get these tattoos, and then a couple of years later they realise what a daft thing that was, and they're then having to get them surgically removed. It's like, well, why be so stupid in the first place? But of course, with kids, they just don't understand the implications of what they're saying. So we got as far as the police tactic triggered the false confession. In the absence of such research, we must rely on the juvenile confessor's account of why he confessed and the particular tactics used by police which triggered or contributed to the false confession. Although we do not have any explanations in every case, one of the most common reasons cited by teenage false confessors is the belief that by confessing they would be able to go home. Well, that kind of supports what I've just said, doesn't it? They had no notion as to what was going to happen. Obviously, it says, the next paragraph starts off, one such case. Well, we could say two such cases because we know about Brendan. One such case involved 16-year-old Alan Jacob Chestnut. So, Alan Jacob Chestnut, a learning disabled 16-year-old, was sitting on his porch, his hand wrapped in a towel, waiting for a ride to the hospital. He had cut his hand when a tool fell on it while he was doing some work in the basement. A television news team investigating the murder of a woman who lived down the street approached him for directions. But Alan did not know where the victim lived. Noticing that his hand was bleeding, the reporter later told the police about Alan, and the police brought him in for questioning. Some 15 hours later, the Cecil County Maryland sheriff arrested Alan and charged him with the murder of Belula Honecker. Their only evidence against Alan was his confession. In order to get Alan to confess to the crime, the authorities fed him details of the crime by showing him crime scene photos of the victim's body, her clothing, and the physical makeup of the apartment. Then they lied. The lead detective faked a call from the state crime lab and told Alan that the lab had matched Alan's DNA to the blood found at the crime scene. According to police reports, Alan just put his head down and began to cry. Soon thereafter, Alan began telling police officers what he thought they wanted to hear. He told them that he went to visit Honecker and she became angry when he refused to have sex with her. He claimed that she had stabbed him and that he wrestled with her for the knife, took the knife from her, and then stabbed her once. The details of the confession were at odds with the evidence police had uncovered. The victim was stabbed numerous times. She was strangled with her bra strap. The killer had smashed a porcelain figure on her head, but this did not deter officers from arresting Alan. Several weeks after the arrest, police learned that Alan's blood did not match bloodstains found in the apartment. By September, further reports confirmed this result. The district attorney, in the midst of an election, continued to keep Alan in custody. In late November, after the district attorney had won the election, Alan was finally released. In December, the district attorney formally dropped the charges against Alan and announced the arrest of another man, Christopher Thomas, whose fingerprints were found at the crime scene and who was linked to the crime by DNA evidence and had confessed to the crime. Thomas later pleaded guilty and is serving a 40-year sentence. But that's interesting, isn't it? Because there is, again, another example of, being freed because of the fact that they found the right perpetrator. But the only evidence against him was the confession. But yeah, a political gerrymandering. Keep the guy locked up. Wait till after the election. Anyway, so according to Alan, in the time frame between the discovery that the blood at the crime scene was not his and the time of his release, he was stabbed once and raped twice in the adult county jail where he was being held. In an interview after he was released, Alan explained why he confessed to a crime he did not commit. Quote, "They kept telling me, 'I know you did it, so why are you lying to me?' They had me so upset, I wasn't thinking right. If I said, yeah, I did it, I could go home. If I said I didn't do it, I could go to jail. So I said I did it, and I want to see my parents and everything." Section C, vulnerable populations, mentally retarded. In Atkins versus Virginia, the United States Supreme Court held that the Constitution prohibited the application of the death penalty to mentally retarded persons. One of the reasons cited by the court for banning this practice was that mentally retarded defendants in the aggregate face a special risk of wrongful execution. In particular, the court noted two such cases in a footnote, both of which involved mentally retarded persons who unwittingly confessed to crimes they did not commit. Sorry about that. The unique vulnerability of the mentally retarded to psychological interrogation techniques and the risk that such techniques, when applied to the mentally retarded, may produce false confessions is well documented in the false confession literature. Not surprisingly, there are at least 28 cases in our data set that involve mentally retarded defendants. One such case, the case of Michael Gales, is reported below. Michael Gales, number one. In the early morning hours of August the 1st, 2000, a mother ran out of her Detroit home screaming, "Someone's raping my baby." By the time police arrived, 12-year-old Janai Glasker, a 7th grade student who was active in the Glee Club, choir and Peacemakers, a student conflict resolution group, was dead. The Wayne County Medical Examiner's Office listed her cause of death as blunt trauma. It was later determined that she had been raped. Within 48 hours of the attack on Glasker, Detroit police had obtained a signed confession from Michael Gales, a mentally disabled 18-year-old. Gales, who had an IQ of, wait for it, 71, and was learning disabled, signed 2 other additional written confessions during the 36 hours he spent in police custody. Gales, who lived 3 blocks away from Glasgow, became a suspect after police received a tip about his involvement in the crime. At the time of his arrest, Gales' mother claims to have told police he's under disability. His comprehension is real low. He's unable to read beyond the 6th grade level. Sound familiar? Gale's first statement was nearly incomprehensible, but his later 2 statements, typed up by detectives in question and answer format, gave more and more detail. In his second statement, Gales allegedly told police that Glasgow had consented to sex but screamed when her mother entered the room. I don't know how many hits I put in her head then when I looked at her. Then I knew she was dead. I panicked and ran, said the second statement. Gale's third statement, taken by yet another detective, supplied a motive for the murder. I was jealous because she seemed to have a perfect, happy life, and went so far as to implicate his mother, who was later charged and released in the cover-up. I love her. She wanted to protect me. She helped me clean up some blood on my hands, on my bottom of my shoes, on my face, and all over my body. I was real bloody. In addition to the confessions, Najai's mother and other eyewitnesses identified Gales in a lineup, and police learned that Gales had a prior juvenile conviction for a sex crime involving a relative. Yet, within 2 weeks, the case against Gales had fallen apart and the charges against him were dismissed and he was released. DNA evidence taken from Glasgow's body failed to match Gales, causing his lawyer, Mark Satora, to remark, "But for the grace of DNA, Michael Gales would probably have served life in prison." Because the interrogations and confessions were not taped, little is known about what caused Gales to confess to a crime he did not commit. It was reported, however, that for 3 hours under intense questioning outside the presence of his mother, because Gales was 18, she had no right to be present, Gales had insisted he was innocent. It was only after Gales was administered a polygraph test and told he had flunked it by the examiner that Gales confessed. Well, amazing, isn't it? The parallels. Absolutely amazing. In response to the dismissal of the charges, Detroit police officers assumed no responsibility for the wrongful arrest. Instead, Commander Dennis Richardson of the Major Crimes Division was quoted as saying, "I think that the city should be very proud of their police department. This was a case where if we wanted to, we could have just hidden the facts or continued forward." Well, we know that you can do that, yes. We didn't want to do that. We want to find the person who is responsible for hurting that little girl. On January the 9th, 2002, Detroit police found that man, charging Ricardo Stubbs, a 22-year-old Detroit man, with Glasgow's murder. Stubbs had been arrested in Memphis, Tennessee, after another Detroit woman he had sexually assaulted and beaten with a metal object had identified him. While awaiting trial on this rape and assault charge and another such charge involving a Detroit woman in the spring of 2000, police linked Stubbs to Glasgow's murder through DNA testing. Subsequently, he confessed. Gales filed a civil lawsuit against Detroit police officers who obtained his false confession, ultimately settling the suit out of court for $800,000. Again, I'm reminded that the dude always goes on about the fact that, you know, it might seem good that you've locked somebody up, but when they're then released and you've got to pay, you know, sometimes millions. I mean, how much are they going to have to pay Steve and Brendan when they could have cut their losses a whole lot sooner? They're just hanging on and hanging on, making it worse for themselves and worse, particularly bad, for the population in Wisconsin. Anyway, Section D, vulnerable populations mentally ill. In this article's database, at least 12 false confessors were mentally ill, a figure which again probably is an underestimate because mental illness is not a fact that appears with frequency in the news accounts of false confessions. The case of Colleen Blue, a mentally ill woman who falsely confessed to killing her child, is reported below. A 9.5-pound a 9.5-pound newborn baby boy's body was discovered near a dumpster behind a Dominic's grocery store in Round Lake Beach, Illinois, in August 2001. There were no witnesses to the baby's death, and in order to solve the crime, the Lake County Major Crimes Task Force had to find the baby's mother. Investigators soon began to focus their attention on Colleen Blue, a homeless woman with a history of psychiatric problems. Blue had disappeared around the time of the baby's death. Furthermore, word on the street was that she had told several people she was pregnant prior to her disappearance. On September the 16th, 2001, Blue resurfaced. During an interrogation by Lake County detectives, Blue confessed to the baby's murder. Allegedly, she told police that she delivered the baby near the Dominics, cut the umbilical cord with scissors, placed the still crying baby in a large bag, covered him with clothing and left the bag next to a dumpster. All facts which only the true perpetrator would have known. On the basis of this confession, the Lake County State's Attorney's Office charged Blue with first-degree murder, and she was held in the Waukegan County Jail until October 21st, 2001. On that date, however, all charges were dismissed because DNA taken from the dead baby did not match Blue's, thereby conclusively proving that she was not the baby's mother. Section E, multiplying effect of false confessions. Section 1, multiple false confessions to the same crime. Another trend which emerges from our database is the number of cases in which more than one defendant falsely confesses to the same brutal crime. There are 38 cases in our database in which this phenomenon has occurred. This represents more than 30% of our sample. Of the 38 cases involving multiple false confessions, 19 or 50% of those confessions involve juveniles. Although the Central Park case contains the highest number of false confessions in a single case with 5, there are several cases in our database with 4 false confessions, 3 cases with 3, and numerous others with 2. In remarking on the Central Park case, here we go, Saul Kassan noted that once detectives obtain one false confession from a suspect, they then use that confession to coerce other false confessions from co-defendants. If the first person to implicate the others is giving a false statement, and then the first leads to the second, and the first two are used to leverage the third, then certainly you're building a house of cards. One of the cases in which police obtained false confessions from 2 suspects and tried unsuccessfully to obtain a false confession from a third, the murder case of Justin Mello, is discussed below. Section A, Frank Nucken and Jonathan Khaled. Justin Mello was a typical teenager. He attended high school, played soccer. That's proper football for Americans. We don't call it soccer here, it's football. What they play over in America is American football. So, okay, I'll go with soccer then. He attended high school, played soccer on his high school's team, and worked a part-time job at Mancino's Pizza and Grinders in New Baltimore, Michigan. On October the 21st, 2000, Justin and a 19-year-old co-worker received a call for a pizza delivery sometime around 11 p.m. Justin had just begun to drive, so his parents told him that they did not want him to make deliveries because it was too dangerous. So Justin's co-worker went to deliver the pizza, and Justin stayed to watch the store. Police suspect that the call was a setup to make the robbery of Mancino's easier. Once his co-worker found out that the delivery call was bogus, he returned to Mancino's to find Justin kneeling in the store's walk-in cooler, shot once in the back of the head. Mancino's cash register had been raided, netting the robber or robbers a few $100s. Mello's murder shocked the small New Baltimore community, which had not seen a fatal shooting in more than 30 years. Justin's soccer coach voiced the sentiments to its residents. It was a senseless killing with no rhyme or reason. It shouldn't have happened to a fine young man like Justin. Police pressure soon mounted to find Justin's killers, and within days of the murder, working on tips from people associated with Mancino's, the police quickly arrested 3 young local men for Justin's murder. Jonathan Khaled, 18, Matthew Daniels, 16, and Frank Nucken, 19. The 3 suspects were charged with felony first-degree murder, armed robbery, and conspiracy to commit murder. Khaled and Nucken initially confessed to the crimes, but they later recanted, claiming that the police coerced them. Based on these confessions, the New Baltimore police pieced together a story of the crime in which one of the 3 made the false delivery call to Mancino's, then Nucken drove Khaled to the restaurant where he killed Justin Mello with a gun provided by Daniels. In light of the confessions, claims of individuals that the 3 men had all been present at the same party miles away from New Baltimore at the time of the murder were not taken seriously, and police threatened those coming forward with alibis with obstruction of justice charges. New Baltimore police had corroborated alibis for all 3, and none of the suspects could provide information as to the whereabouts of the murder weapon, but they nonetheless focused solely on Khaled and Nucken's confessions. After a preliminary hearing, charges were dropped against Daniels for lack of evidence, after he had spent about a month in jail for Mello's slaying. The testimony of 2 witnesses who were to implicate Daniels quickly fell apart on the stand, as one claimed to have been coerced by police into giving false testimony, and the other took the Fifth Amendment. The 2 other suspects, however, were held over for trial. Judge Paul Cassidy, presiding over the case, revealed the community's bias when, after setting Daniels free, he said, "I personally find that Mr. Daniels too is guilty. After today, Matthew Daniels and his supporters will be free to claim his innocence and the injustice of his arrest. But we who have been here, present throughout the testimony, will know the truth to be otherwise." At his hearing on his motion to suppress, Khaled testified that he confessed in part because he knew that police would not be able to find any additional evidence against him and then would have to let him go. Well, that's exactly like Brendan, isn't it? Further, he claimed that police yelled at him, threatened him, promised him leniency, and told him that he would not last long in prison because other inmates do not like little kids like him in prison. Nucken made similar claims as to how he was coerced into confessing, but he also claimed that the police convinced him that he must have blocked the traumatic events out of his mind. The presiding judge, however, refused to believe that the two men would confess to crimes they did not commit, and ruled that their confessions were not coerced and consequently admissible at trying. As prosecutors and defence attorneys prepared for the boys' trial, the arrest of two other men in Kentucky, David Borman, 20, and Dennis Bryan, 19, quickly threw a wrench into the case. Police soon discovered that Bryan and Borman were involved in a 37-state crime spree, which began with the embezzlement of at least $20,000 from a restaurant in New Baltimore where both had worked, and ended in the deaths of at least 3 people. Strangely, both men had previously worked at Mancino's, another nearby franchise of the restaurant where Justin was killed. However, even stranger was the fact that one of the crimes for which Bryan and Borman were being held mimicked that of Justin Mellow's murder. A Subway restaurant store clerk in St. Augusta, Florida, was led into the walk-in refrigerator, forced to kneel and shot in the back of the head. Despite the similarities between the two killings and the link between the two and Mancino's, New Baltimore police and prosecutors still insisted that they had the right men in Khaled and Nucken. Initially, police ruled out Bryan and Borman as possible suspects on the grounds that the bullet that killed Justin did not match any of the guns the pair had in their possession when they were arrested. Ultimately, however, ballistics testing matched the gun used in the murder of Justin Mello to one found in the possession of Bryan and Borman. Police were also able to identify the gun as one of many stolen in the murder and robbery of a gun shop owner committed by Bryan and Borman in Virginia. With the evidence mounting against Bryan and Borman, New Baltimore police still refused to concede that Khaled's and Nucken's confessions could be false, and continued forward with their charges against the two under a new theory. Police surmised that the gun was stolen in Virginia by Borman and Ryan, driven back by them to Michigan, and transferred to Khaled, who then used it in the murder of Justin Mello. According to this story, Bryan and Borman then retrieved the gun and used it in the botched robbery attempt in Kentucky, for which they were arrested. Nucken and Khaled, however, insisted they did not know the other two suspects, and police could not establish that Bryan and Borman knew Nucken and Khaled. While the local police repeatedly assured the public that they had the right men in custody for the murder of Justin Mello, it was the mothers of Khaled, Nucken and Daniels whose investigative work led to the dismissal of charges against their sons. In April 2001, all 3 women travelled to Kentucky, where Borman and Bryan were arrested, and then to Virginia, where they were being held for the murder of a store clerk, to follow the pair's trail of crime. The women were assured by attorneys and law enforcement officers in both locations that their children were not guilty. Just 2 weeks after his mother's trip, Borman confessed to the murder of Justin Mello to Michigan authorities. Finally, in April 2001, charges were dropped against Khaled, Nucken and Khaled. It was the confession of Borman that ultimately led prosecutors to drop charges against the pair, after they had already spent over 6 months in jail awaiting trial for the murder and robbery. But in some ways they can count themselves lucky that, they did eventually get hold of the right people. But yeah, just the fact that they're just holding on to this confession as if it's the gold standard of evidence. Anyway, in October 2001, Khaled Daniels and the late Frank Nucken, who was killed in October 2001 in an unrelated stabbing, filed lawsuits against the law enforcement agencies and municipalities involved in their ordeals. Well, we'll hold it there then, just before we go to the next section, which will be number 2, multiple innocent defendants arrested, charged and convicted based on co-defendants' false confessions. I was trying to work out what page number we're at. Oh, there we go. We're around about page 87, going up to we're on page 87. So we're not very far from the end of this article. Maybe a couple more should just about do it. Anyway, thanks to everybody who's been tuning in. Obviously, this kind of stuff, it's kind of heavy going, both in terms of obviously legal jargon, but also pretty heavy going. As I say, I'm still baffled by the arresting the 2 little 8-year-old kids, and then the experts saying they're harmless. Oh, but we're going to electronically tag them, and they had to get special ones because the kids were so small. It's just bizarre, isn't it? Anyway, we'll catch you all again soon. Bye for now.